Securitization to levy on paycheck. Employer filed Form 1096 to pay corp income tax with employee's salary and using accounts payable direct treasury account. Use Form 1099 OID. Corrected box checked. Form 1096 and 1040. For refund. Keating's letter to bill collector law firm. Dear Mr. Doe, I am writing regarding your recent letter in regard to your client XYZ Corp. being the alleged creditor in the amount of $1,100. Your alleged client has waived their status as a creditor when they accepted my tender of payment under UCC Section 3409 and B and UCC Section 3604. They did not adjust their accounting ledger to reflect settlement and closure of the accounts receivable side of the accounting ledger. By way of review, I sent the woman in the credit department of the creditor a negotiable instrument on April 24 in the form of a commercial note draft, as an order to pay under UCC 3104(e). This may be treated either as a promise to pay or an order to pay. Since she has not returned the instrument to me, she has obviously chosen the latter, an order to pay. Under Section 3104(f) of the UCC, a draft is the equivalent of a check and may be securitized or monetized by direct deposit in a commercial checking, time, thrift or savings account under Title 12 of the United States Code, Section 1813, L.1. And when deposited, it becomes the equivalent of money as outlined under Section 1813, L.1. The collection manager from the credit department of the creditor did, however, send me a letter saying that she did not accept promissory notes. She is, however, precluded by Public Policy H.J.R. 192 and Title 31 of the United States Code Section 5118, D.2, and the Fair Debt Practices Act, ECA. Consumer Protection Act at 15 U.S.C. Section 1601 and Section 1693 from demanding payment in any specific coin or currency of the United States, even though she has not done so. Section D.2 of Title 31 U.S.C. Section 1518 states that an obligation governed by gold coin is discharged on payment dollar for dollar by United States coin or currency that is a legal tender at the time of payment. The narrow view that money is limited to legal tender is rejected under Section 1201(24) of the UCC. It is not limited to United States dollars. See official comments under Section 3104 of the UCC under the definition of money. The woman at the creditor has failed to perform her duty as fiduciary trustee of the account. I have done a notarial protest against her and the account for non-acceptance and payment under Sections 3501 and 3505(b) of the UCC, which creates the evidence or presumption of a dishonor. She has knowingly or unknowingly become the debtor and myself the creditor by operation of commercial and administrative law. Also worthy of note, if she is going to treat the note as a liability instrument, she has to present it to me for payment, make me chargeable under 3501 of the UCC, which she has also failed to do. To the extent that she is in dishonor for non-acceptance and non-payment by notarial protest on the administrative side, there has been a discharge of the debt in its entirety under the Fair Debt Collection Practices Act within the 30-day time frame as mandated by law. I have been teaching and studying commercial banking law and intermediate and advanced accounting for 36 years. I have a degree in commercial banking law, 4 years in undergraduate study at USC and 4 years at Hastings School of Law in San Francisco. This is for your edification and exhortation. Since I am reasonably sure that we can come to a peaceful resolution of this matter, as your client does not understand commercial banking law, and the IASB, the FASB and GAP principles as they apply to commercial banking. I do a lot of trading and purchasing in commodities and securities exchange market where the use of irrevocable standby letters of credit, documentary drafts, international bills of exchange, or promissory notes are used exclusively under the Unicitral Convention. Your client is not applying the correct accounting entries under GAP. She is treating the account as a trade receivable through securitization as an off-balance sheet financing technique. Since she has accepted the instrument that I have tendered, I have a claim or possessory right in the instrument and its proceeds under 3306 of the UCC. Any defense and any claim in recoupment under Section 3305 of the UCC, which I shall exercise at my option, if she does not credit my account. The 1099 OID will identify who the principal is from, which capital and interest were taken, and who the recipient or who the payer of the funds are, and who is holding the account in escrow and unadjusted. Since I am solution-oriented and want to show good faith, there are two ways of resolving this matter. Since your client has already accepted my tender of payment and has not returned it, you can instruct her to credit my account for the sum set in full for settlement and closure. Or, instruct her to return the original instrument to me, unendorsed, and I will make an alternative form of payment. Otherwise, I will consider this matter settled and closed. End of letter. Jax comments the woman at the creditor can't send the promissory note back because she has already negotiated the instrument. No one ever gets promissory notes or BOs returned because a debt tendered and refused is discharged. She kept the note and wrote a letter saying that she doesn't accept promissory notes. But her actions speak louder than words. She accepted it. So it has already gone into the corporate liability account, but it didn't go into the corporate asset account for ledger. A debt tendered and refused is a debt paid. We sent an IBO to a bank and they negotiated it and said they returned it. But they didn't return it. They deposited it and it became cash proceeds. So whenever you send them the note or BOE, they keep it in their deposit system and it becomes a cash item. They get a cash receipt for the deposit. If you don't understand accounting, they get away with the theft of your instrument. In reality, you gave them the instrument to settle and close the account. Your instrument is an asset to you. It appears that you created a debt instrument, but the opposite is true. The government has no authority under the Constitution to create money. So only the people can create money. So we are the originator of money, so we are the creditors. But they make you believe you are the debtor as if they are the creator of money. The only way you have an accounting of the instrument is in the bookkeeping. And they are keeping the account on the off-balance sheet ledger. If they know you know what they are doing, they won't try to hide it. When they go to a collection agency, they are selling the account as a trade receivable from the asset side of the bank's ledger. If the bank is trying to collect money, the evidence of the debt owed on their books is on their asset ledger, accounts receivable. If you gave them a promissory note, they have to record a debt to you on their liability ledger. When the U.S. citizens became enemies of the state in 1933, they were not required to notify them of their assets. They are not required to notify enemies of their assets during times of war. They are not required to return enemies of their assets. So they are kept on hidden books. When you send the collection agency the above letter, it creates a fiduciary duty for them to go back to the principal to check the off-balance sheet liability ledger to determine if the account has been paid and if your claim is correct. This principle applies to the IRS and the courts. They only want to discuss what you owe them and ignore what you pay them. The reason they tell you that your negotiable instrument is no good is that under the Trading with the Enemy Act, they cannot allow you to create your own negotiable instruments or use your own assets. All they have done is keep the ledgers separate. The receivables book has not been ledgered. That is why the collection agent says they have not given you credit and you still owe the money. The debt collector buys the account receivable in good faith without evidence of its accuracy. It is like a charging instrument. The attorney says pay up or we are coming after you. Under Civil Rules of Procedure, Rule 13, commerce is adversarial, so they are not required to tell you the whole truth. It is mandated that the defendant return a counterclaim with facts proving that the charge is untrue, which is an affirmative defense. A claim is an account that has matured for debt collection. You must show you are a creditor. The charge is a presumptive claim with no evidence. A notice of lien or levy has no evidence of a claim. It is just a charge. A notice is a claim of jurisdiction. A counterclaim is not a dispute or argument. Disputes are not permitted. If the merchant had brought a claim, it would have been a fraud, because you already paid it. So they just give you a presumptive notice. It is an unsupported charge. There is probable cause with no evidence. You have to respond to it because it will become valid if you don't. It is just a notice of interest. It can mature to a claim with your failure to respond. You have to accept it and return it with your notice of interest, which is a counterclaim, within 10 days, according to Admiralty rules. Failure to do a specific negative affirmation of the facts alleged. Rule 9 constitutes an acceptance of this fact as far as the courts are concerned. A notice of interest matures to agreement of the parties that they have a valid claim so they do not have to prove it. An unsupported notice of interest becomes an agreed claim. They are not guilty of fraud, deceit, or trickery. Your failure to respond is the problem. Our responsibility is to rebut the assumptions and presumptions under the rules of evidence. Gene did everything he needed to do in law and at law to resolve the issue. The merchant handling the books was only handling the accounts receivable books for the corporation and was not privy to their accounts payable books, which are their liability books. The reason the corporation separate their bookkeeping is they can bring this woman in with a straight face and no knowledge that the other books exist. Swear in court that she's been handling these books for years and the account still has an $1,100 balance. You sent in an instrument that had nothing to do with affecting the balance on the books she handles. When that corporation did a deposit of your promissory note, or BOE as a cash item receipt, that went into the other set of books that she doesn't see, she can use her affidavit and swear that this account is still open. Whereas if you knew the accountant on the other set of books, and subpoenaed those books, you would find something on the ledger over there and there hasn't been a transfer or exchange of information between the two sets of books. You need to bring the knowledge of that forward to a Data Integrity Board hearing. I don't disagree with anything that this lady is saying. However, if you would go over to the corporate liability off-balance sheet ledgers, you would find that there has been a set off deposited there, and if you could see both sets of books, you would see there is a set off, which is a claim under Civil Rule 13, which I am timely invoking, and I am asking you to look at both sets of books and do the offset balance and do the settlement and closure in this matter. Remember, the firm hired an attorney collection firm. The collector came with the charge to Gene. How many times has Gene been charged by different entities in this case? Twice, so they can have 2 or more witnesses. The first time he said to the receivables lady with the merchant, "Here is a promissory note." She made a determination that she is not going to accept it. But the note didn't come back. So now the corporation sells the account to an attorney and the attorney writes a letter to Gene. Gene raised a Rule 13 affirmative defense in his letter back, showing by the accounting what the problem was and describing the claim he would make in court. This attorney's company is the second set of witnesses acting as the Data Integrity Board trying to find out why you haven't paid. So you should give them your records so they can compare your records with the corporation's records and decide whose records are correct. Let him know that 1. You did not get the note back, so they're a holder, so they're liable on it. 2. This was meant as a set-off on the corporate liability books because they kept my note. They should have given him a cash receipt for the note. The woman in receivables is only looking at the corporate asset ledger. That is an affirmative defense and a set-off claim that the law can recognize. The attorney's company can either go back to the corporation and close the case or else, if it goes to court, this is going to be my affirmative defense and my counterclaim in court because I have an asset that the corporation is holding of mine, that they failed to give me credit for. Where they made their mistake is that they are likely carrying my asset on a liability ledger of balance from their accounts receivable. What I am asking you to do, as a Data Integrity Board, is to investigate to determine which one of us has the most sustainable evidence. The attorney firm was put there as an opportunity for you to have a second witness to look into the matter and settle the account. They don't usually have to investigate the information that is sold to them by the corporation. They don't have any probable cause to believe different. In an adversarial system, it is up to you to tell your side of the story. Every debt collector writes in his letter that, if you have any reason to dispute this debt, let us know. You have to send them your claim within 10 or 30 days. Do not argue or create a dispute. Simply give them the facts of your defense. Gene put in his note a promise to pay, an order to pay, and a notice of tender of payment and asked them to credit it to the accounts receivable. He should also have asked for a cash receipt. It would be fraud if the corporation kept after Gene, so they sell the receivable to a third party that doesn't know the whole story. They are a new party. When a new party comes after you, they have no standing under the UCC to do it. But if you argue, it causes a new controversy. All you do is present your claim that shows you are the creditor in the transaction. The new holder has to be the Data Integrity Board. So he is your best opportunity to settle and close. Don't ignore him. The IRS has a notice of lien or levy. It is a charge or notice of interest. Don't argue with them. You should rebut it under Civil Rule 13. Otherwise it stands as fact and they don't have to prove anything. The government and their agents are here to test us. If we want to pass the test, we should have a claim for set-off. We must act like creditors, not debtors. Jesus paid for all our debts. Jean did the notarial protest on the note. It becomes the evidence that you put in your claim. It is critical that you register the note on a UCC-3 to make it a public record. Victoria used a note to discharge her parole. However, she did not register the note on her UCC-3, so it was never recognized in the public to settle and close the matter. So her charge was sold to a Hong Kong company who requires a wanted notice maintained on her as their notice of interest. You don't need any evidence to issue a notice of interest. IRS notices of lien or levy are just notices of interest. You have 10 to 30 days to respond with a counterclaim. If you don't respond, they have a claim by default. Arguing creates the IRS claim by default. We are a creditor when we discharge the debt, but we never respond timely with a counterclaim to show we are a creditor. Since the IRS is just a debt collector, they are the best place to have a Data Integrity Board hearing to settle and close the matter. Arguments about the law are not counterclaims. If we don't bring a claim, we lose. If we discharge the debt, and they keep the note, we have a claim as a creditor. The note cannot be introduced as evidence of the claim. If they kept the note without giving a receipt, your record is the UCC registration of the note. Don't put the invoice AR4V on the UCC. It is a liability, not an asset. The BOD becomes a registered security under UCC Article 8, which are superior to other UCC articles. The court will not look at any security that is not registered in the public. You should register your bank mortgage note on your UCC-3 to establish a claim. The mortgage note is a security and it is never registered. The finance system is dealing in unregistered securities. They cannot take an unregistered mortgage note into a court for foreclosure. They never produce a note in a foreclosure because it is evidence of their liability and not cognizable in court. We are the creditor on the mortgage note, so we should register it. As soon as we register the mortgage note, we become the creditor in the foreclosure case with the highest interest. If we tendered a BOE to settle and close a criminal case, it should be registered. The clerk never gave us an accounting for credit, so they will ignore it because we didn't make a Rule 13 counterclaim. We must register the BOE on a UCC-3 and bring a UCC-11 in as a counterclaim. All other arguments do not matter because all law is an illusion. They converted everything to a commercial transaction at the beginning of the case. People have filed UCC liens listing the bank as the debtor. The debtor should be the prepaid account at the Secretary of Treasury of Puerto Rico. The straw man should be a third-party creditor because he is a bailee on another filing. The living man does not appear in their system, so the straw man has to be the creditor. All parties on a UCC filing have to be a fiction, not living. The SSN is the account number. The living man is responsible for all transactions. When Gene sent his claim to the collection agency, they had the fiduciary responsibility to go back to the corporation and ask to see the off-balance sheet liabilities ledger to check out the claim. When you give them notice, they have to go to discovery under Civil Rule 11. He has to find out who is responsible for the accounts payable ledger and what did you do with the cash receipt for his deposit. I want to see your 1099 OID, Statement 95 cash flow statement and your balance sheet. Gene will not likely hear from these people again. Gene presented a credible counterclaim. The note was an asset to him and a liability to the corporation, and they didn't account for it. The debt collector can't resell the receivable now, because he has had notice. The sale would not have been in good faith. The woman in the original company was operating in ignorant good faith. She only saw half the books. You may have to go through the administrative procedure against him if he ignores your claim. After he has seen both sides of the books, he would be operating in fraud. The Enron executives that got in trouble were the ones that saw both sides of the books. Securitization is fraud. Some companies pass the receivable on to fourth or fifth parties so they could have clean hands. But no one ever told them about the second set of books. We have not given them a registered security. There is no evidence in the public record. They can carry the illusion that your instrument is worthless forever. If we do not understand that the collection agent only sees the receivables and not the payables, we will fail to state a claim. This puts us into commercial dishonor, which gives them the option to take us into court to force us to pay in Federal Reserve notes. So the first court case is actually an appeal from the administrative process. One is not allowed to introduce a new claim in an appeal. The factual hearing was with the collection agency. We are foreclosed from bringing our claim. One must raise the claim at the appropriate time, or you have not exhausted your administrative remedies. We need to get a data integrity review hearing or a secondary hearing because we have new evidence to be adjudicated. The Truth in Lending Act, TILA, Section 226.23, which is Regulation Z, gives one the right to rescind any commercial debt contract or agreement entered into. All commercial contracts for credit or loan provides for 72 hours to do a rescission. That can be extended for 3 years from the date that one discovers that one did not have full disclosure. In Appendix H, it says that this Regulation Z does not apply to residential mortgage transactions. However, once foreclosure has been initiated on a mortgage, one can rescind it if they did not disclose the right to rescind at closing under Appendix H. They never give the proper notice at closing. So one could rescind every mortgage contract at foreclosure. They give this option because one could have registered the note on a UCC. One would be the creditor anyway, and so they can't foreclose. Rescission completely discharges the security agreement, the mortgage deed and the mortgage contract. One can ask for the entire amount of the mortgage note returned in the form of cash. They should have given you the cash for your note at closing and closed the whole transaction without continuing payments. The house was paid for at closing with your negotiable instrument on one set of books. They didn't give you credit for the note because you didn't register the note and show a claim. If you don't register the note, they will not give you your property back. They can't give you the note back because they sold it. So, they should give all your payments back. God has given us a prepaid account so we never have to go into debt. If we are honorable, we should pay for everything with a promissory note. All homes are legally abandoned because no one has made their claim for the money that was owed to them. One should have claimed the house at closing because the note paid it for. The bank has no claim. There is a third party that bought the note from the bank and holds an interest in the note. Foreclosure is damage, so they have to give notice and the right to rescind. The notice of rescission is sent by certified mail. As soon as we do that, they try to claim that Reg. Z doesn't apply to residential mortgages. In the Henry Maxwell case, the owner repeatedly asked for disclosure. We used this case as a foundation for our case on the ground that the mortgage transaction was an unconscionable act. Whenever there is a lack of disclosure, one has an offset available. This is dangerous to the entire mortgage industry. However, a few cases is not going to cause a big problem. If most people want to be ignorant and be slaves to the banking system, they have the right to do that. No attorney will make this type of claim because it jeopardizes the system that he works for. Nor was the attorney told what to do by the client. Regulation Z shows the form in which the bank is required to give notice of rescission. They never give you notice in that form. They awarded the owner $475,000 in punitive and actual damages from the bank. Plus, they rescinded the contract. They said the contract was unconscionable under UCC 2302. One also had the right to rescind if the property is on a floodplain that was not disclosed. Many new floodplains have been declared. The whole state of Ohio is surrounded by navigable waters under USC Title 33 and is a floodplain. Where the high water mark goes, one is subject to Admiralty maritime law providing federal jurisdiction. It is caused a hazard area under Title 42 USC 4012. FEMA defines the floodplain. There was no flood insurance on the property when the loan was originated. It is not possible to take out a loan in a floodplain area without flood insurance. That voids the contract. The claim or affirmative defense is that this is another ground for rescission. They never disclosed that the property was in a flood hazard area and there was no flood hazard insurance. That is a violation of UCC 3407, a material alteration to the original contract. The government is trying to expand the definition of wetlands and floodplains. This is related to securitization, in which they transform negotiable instruments into securities. They move them from UCC Article 3 to Article 8. Ohio Code Section 1707.01 b. A promissory note is defined as a security, so one can use rescission on it also. Under Ohio Code 1707-261, one has the right to restitution and rescission when they sell an unregistered security. As soon as the bank gets your mortgage note, they sell it. Banks register mortgage deeds, not mortgage notes. Victoria gave a note to the county to discharge her criminal case. The county likely deposited it in a bank and received a cash receipt. The bank likely sold it as an unregistered security. This provides Victoria with another remedy. But she needs to register it on a UCC 3 before it can be used as a claim. End of September 18th meeting.